Hello, YouTube. I'm Vince White. I'm an employment attorney, and we have a question from YouTube user Brandy Thompson, who she asks specifically, "What is an order for discovery plan?" Question mark FRCP, Federal Rules of Civil Procedure, F26. Okay, so this is for all you pro se litigants out there. This is not legal advice. I'm not giving you legal advice. I will not help you with your pro se case. I will try to make videos, very general videos, answering general questions, not applying it specifically to your case, because I don't want to take on liability on your case, and because a bunch of idiots are going to run around posting nonsense on my videos like, "You didn't help me at all," and it's like, right, I'm not your lawyer, so yes, it's correct. I didn't help you at all, besides answering general questions for free. But I know Brandy Thompson, I've been generally answering questions for this individual for some time on the internet, and this individual is a delight, so I want to help. So here we go. I am going to link in the doobie-doo down below a PDF put out by the Southern District of New York, which is a federal court, and it deals with Rules 16 and 26F of the Federal Rules of Civil Procedure, and it is a civil case discovery plan and a scheduling order. And this is the kind of thing you're going to see if you're engaged in a federal litigation in most federal district courts. There can be variants, there can be changes. Everything is not the same from district court to district court. Be aware of that. And be aware that I'm talking purely in generalities. Only generalities, not your case. Only generalities, not your case. None of this is directed at you, Brandy Thompson, although, of course, it's still true. I'm not your attorney and I can't give you legal advice. But that being said, I am trying to give you information. So, I'm going to attach the PDF. You might want to open that PDF while I'm speaking because it might be useful. If you're a pro se litigant, if you don't have an attorney who knows what they're doing to walk you through this, some of this may look like gibberish, right? So you're going to open it up. It's the civil case discovery plan and scheduling order. There's the caption at top. It tells you who the plaintiff is, tells you who the defendant is. And essentially this is an order the judge will issue, the judge or magistrate, I should clarify, will issue to make sure that there are dates and deadlines and we have a schedule and we know what's coming, right? And when things are due. Will this order be held to? Depends on the judge. Depends on the counsel involved. Some judges are very relaxed about allowing extensions. Some opposing counsels are certainly going to consent to adjournments of certain dates if they can, right? Other judges and other opposing counsel will tell you that they're going to bury you 6 feet on the ground if you don't meet your deadline. So, and also your attorney, frankly, if you're represented by an attorney and you're like, why do we keep missing our deadline dates and then adjourning it? Well, that's because your attorney's not getting her or his job done as per the deadlines in the scheduling order. So you may want to be aware of that. That doesn't mean they're a bad attorney. Doesn't at all. They could be adjourning for really good reasons, like they want to produce witnesses, or there's issues with forensic discovery on the IT front. There's so many things that can go on, right? It doesn't mean they're a bad attorney, but it is something to be aware of. Why is my case taking so long? Well, how many adjournments happened during the discovery process? It's worth checking into, okay? Now, turning back to the document, you're going to see, is the trial going to be in front of a jury or not? This is something that would have been selected at the time the complaint was filed. So, listen, it can change. But whatever it is now, there's a good chance that's how it's going to be going forward. It talks about pleading, and item number 2, we look at the options for amendments, joining parties, things of that nature. That's super complex. If you're amending pleadings, if you're adding parties as a pro se, God help you. I can't. It's beyond what I can do for you. It's a lot. So initial disclosures. There's a bunch of videos on the internet about initial disclosures. That's its own realm. You need to know what you're doing there, so you should do a lot of research on that topic. Then in 4, you get into fact discovery. And right off the bat, A, you're looking for the date here. All fact discovery must be completed by blank, right? That is the date that will be set during which either the parties agreed or the judge set everything has to be done by, okay? That is not necessarily hard and fast, but some judges will view it as hard and fast, so be aware of that. Then in B, you're getting into initial request, interrogatories, which are their own world. It's a bunch of questions you're asking each other. Each side is going to ask the other side. D, you get into dates for non-expert depositions. So that's going to be your witnesses, generally. And, okay, here we go. Request to admit must be served by such date. You're going to want to know what a request to admit is. You're going to want to look that up. That goes beyond what I can do in this video because we're just taking a glance at the discovery order. It goes on. Then you get into expert discovery. What is an expert? Well, that is something this profession, the legal profession, spends a lot of time on. You're going to have fights about who your economic expert is, who your expert is as to testify to mental health and mental anguish and the emotional damages, right? You might have an industry expert. There's lots of experts, and there's a lot of fights about are they qualified, are they not qualified, whose expert is better. These matter. These matter much. All the matter. Very important, okay? They are as important as the witnesses who saw what happened in many ways, right? Witnesses can tell you what happened and who should maybe be found guilty here, right? But the experts are often going to tell you how much that is worth. And that matters. Matters a great deal. So that's what you're looking at here. It's just interesting. I thought it was useful. Brandy Thompson, I hope this was helpful in some way. And as always, cheering for you. Go get them. If this was helpful, speaking to you, my pro se litigants, who are going to type nasty things to me, because you want me to run your case for you, apparently. I don't know. Again, not Brandy Thompson. It's just the idiots who like, you didn't do my case for me. Yeah, again, not your attorney, idiot. I mean, if you don't like your attorney, get a better attorney. But don't go on the internet being like, why didn't this YouTuber run my case for me? Shut up. You're an idiot, right? But if this was helpful, like and subscribe. It helps me to help more people like you. And, yeah, I hope this is helpful to somebody. If it's not, definitely leave a comment telling me how I didn't help you. It's going to be important that I know that. Take care, everybody.